So, intellectual property rights are reserved for the most subdued parts of our brain. Grant is the beginning of the patent game, not its end. Hola, buenas noches. A very good evening to one and all present here. Hope you all are safe and secure in respective homes. Well, I, Angelina Titus, will be your host for the day, and I consider it to be my utmost privilege. Honorable Speaker, Mr. Pratik Chaudhari, Principal in charge Dr. Atmaram Pawar Sir, Vice Principal Dr. Varsha Pokarkar Ma'am, Vice Principal and Dean Dr. Janvi Rao Ma'am, President of IIC-PCP Dr. Chadwar Patil Sir, Vice President Dr. Dipali Bansuri Ma'am, teachers and all students. On behalf of Institutions Innovation Council, Pune College of Pharmacy, I cordially welcome you all to the webinar on intellectual property rights. I express my sincere gratitude to our speaker, Mr. Pratik Chaudhari sir, who will be enlightening us on the intellectual property rights, the innovative ideas that are worth $1 million. Mr. Pratik Chaudhary sir is a partner at YG Trivedi and Co. Ahmedabad, India, and has been associated with the firm since 2015. As a partner dealing with litigations, he has played a pivotal role in handling a variety of intellectual property lawsuits, ranging from patent infringement cases, trademark infringement to breach of trade secrets, confidentiality agreements, copyright and design infringement cases, etc. He has special skills in drafting legal documents, including IP transfer agreements, court pleadings, and etc. He has been often consulted by the corporate clients on the complex matters involving IPR. Mr. Pratik Chaudhary has been fortunate to have both technical and legal qualifications. He has completed his master's in pharmacy from Gujarat Technological and University in 2012. He also holds a master's degree in law from Gujarat University, having cleared his bachelor's with the gold medal along with diploma in patent law from NALSAR University, Hyderabad. He has a past experience of working in a formulation development department of a reputed pharma industry. We are so overjoyed to have you amongst us, sir. Now, I would humbly
Thank you.
request Mr. Pratik Chaudhary, sir, to kindly illuminate us with his talk.
Yes, thank you very much for the introduction. Thank you very much to the organizers and Pune College of Pharmacy for having me, on this wonderful platform where I can share with all the stakeholders of the industry as well as the students and experiences as an innovator in past, and also the cases which we come across where the innovators they fall short with regards to intellectual properties, and what points they should consider, they should keep in mind before they venture into the field of going ahead with the invention which they are proposing to go ahead. Basically, I'll start with the presentation first, and I'm sure that, okay, I think. Okay, so I think, is my screen visible to everybody?
Yes, sir. Yes.
But I think there is some problem.
So you can select the share PowerPoint option over there.
But it does not include the file physically. Okay, by the time it starts, I mean, I can start with my talk by the time. Basically, this topic I think is very much apt, and I feel really honored that I can share my views on this topic, especially the intellectual property components at the initial stage of innovation or idea. The reason being is that myself, when I entered into pharmacy, I think in third semester or probably fourth semester of the bachelor's course, I remember that there was a subject called pharmaceutical jurisprudence. I hope you guys must be studying that subject. And in that subject, I came across the word patents for the first time. That was one of the patent act, along with drugs and cosmetic act and other act, was one of the part of that subject. And I really wondered that today I feel that it would have been much better if that subject would have been much elaborated in the syllabus of B.Pharm. The reason being that when I entered into masters in pharmacy, it is during that course when the in-depth study of patent act was introduced, and I came to know about what basically patent is. But again, I had no idea about how to go ahead with this particular branch of intellectual property right. What point should I consider before I opt for any topic for the thesis which I'm proposing to present during my master's course. And ultimately it so happened that despite of the fact that my topic for my thesis in master's course, though being novel, it lacked industrial applicability, and for that reason I could not go ahead with the filing for a patent for my project work. And that thing basically was revealed when I ventured into I transitioned from pharma to techno-legal, that is the law field. So I really feel that it would have been much better if I would have been aware about the legal jargons of patent. The Even right now, when for several other colleges in Gujarat, when we provide our advices to various students and professors and the researchers in colleges and university, we usually see that students, when they propose their projects in M.Pharms or B.Pharm, the general notion which they have in their mind is that their project title or their project topic ought to be novel. That is I think where they are missing out, as I missed out during my curriculum. See, novelty in your project or novelty for your research work is not enough to get a patent. There are three other ingredients which are also required. That is inventive step, which is very much important for your invention, and industrial applicability. These two are, according to me, the most prominent feature which an innovator must consider apart from checking the novelty. The students, they generally what they do the Google search. They find out that how many number of hits they get on the basis of the title which they propose to go. Even various researchers, let us forget about students, let us think about the industry people. Even they think that, sir, this is novel, this is groundbreaking, we must get patent. But that is not how it works under the legal ambit or the legal boundary. uh, so generally what one must do, so before you go ahead with your project work, apart from novelty, you must check what problem does your proposed invention solves. This is the most basic component of IP which you must check before the innovator goes ahead with the title they have proposed. Does it solve any problem which is associated with the said product? For example, when we talk about pharmaceutical inventions. So in pharma inventions, generally the students, they generally propose that when particular active pharmaceutical ingredient which was generally being given through oral route, they come up with the project wherein they try to form or to make a formulation which can be administered through nasal route or some other route, and they say that, sir, it can be patentable or not. The answer is no, it cannot be, because you must identify how your new route of administration or how your new dosage form can be more bioavailable, more absorbed, and it shows more efficacious remedy as compared to the the conventional or the old method of administration. So that is how it works. Also, I think all you pharma students and other science students must be aware about the landmark case of Novartis versus Union of India, wherein the new salt form of an already known anti-cancer API was not granted the patent. In fact, the patent was revoked for the very reason because it was not patentable. Just by making a new salt of a known substance, you cannot expect that you'll get a patent if unless you show that it shows a significant efficacy over the over the disease for which you are proposing to get a patent for the new salt. Uh, with that, I'll again try to start my presentation. Yes, now I think it has been loaded on my drive. Yes, so I think now is it visible to everybody? Uh,
Yes, sir, it's
Miss
visible.
Maitri and Miss Janvi, is it visible? Yes.
Yes.
Yeah, thank you. So basically, I will just quickly take all of you guys through, as our Honorable Prime Minister said recently, that my motto for the young scientists in this country has been to innovate, patent, produce, and prosper. These four steps will lead our country towards faster development. That is very much correctly said. Even the ex-president of USA even said in 2009 in the radio forum that innovation has been essential to our prosperity in the past and it will be essential to our prosperity in the future. Angela Merkel from Germany, even she says that it is a duty to protect the intellectual property rights. Now, it is estimated that in a decade or so, as much as 90% of the value of the world's top 2000 enterprises will consist of intellectual property. So the question that does intangible asset. So basically IP, when we talk about IP, it includes patents, trademarks, copyrights and designs, semiconductor and integrated circuits. All these assets are basically the properties which are generated from the intellect. That is the mind of a human being and hence cannot be touched. Hence they are called intangible assets. So intangible assets, nobody thought a decade back or 2 decades back that it will be talked about. And I can understand why this topic is very much important is because on a lighter side, post Diwali, uh, while we come out from the vacation mode and go into the routine lives, today we are sparing 1 hour, that is 5 to 6, to discuss about this topic coming out from the vacation mode. That shows how much important this topic is. So intellectual property basically is the creation of mind. This is just a gist. In I think 45 minutes is just tough for me to explain everything, but I'll go very fast to give you a gist of what it is. It is a creation of mind and a result of creativity. It can be artistic, it can be scientific, and it has some goodwill associated with it. Now, what are the characteristics of IP, which every researcher, innovator, student, industry person must know? Intellectual property can be owned, just like a land or a building or a property. It can be owned by anybody. Once you own it, once you register it, you get exclusive right to use it for a limited period. These rights are very special rights, which is right in REM. It is transferable just like any other land or property or anything. You can transfer it to somebody, you can assign it to somebody, you can license it to somebody, you can put it on rent in general parlance if we talk. It is a territorial right. So once you get the registration of a patent for your product or process or trademark or copyright, you get those rights for India if you get it registered in India. It is a valuable asset and it is, of course, intangible, you cannot touch. Now, intellectual property, why, how, and what it is. So this is a very favorite slide of mine, which I generally pitch to the students to make them understand what it is. You have got an idea. If you can express it on the paper, you can express it on the computer, you can express it in some other manner, which is artistic or literary or has a cinematographic work that is protectable under copyright. It includes diagrams, maps, charts, flowcharts, computer software, object code and source code. It is all covered under the copyright. So general notion which the inventors, innovators, or people have, that they can secure a copyright over a scientific invention, or they can patent a software. So there is much difference between the terminologies. So if your idea is innovative, it has some scientific meaning and solves some problem, it is an invention, then it can be covered under patent protection. If you have got an idea about branding your product or services or your company or your venture, so that name by which your business or your product will be known, it is called a trademark. Now suppose there is some three-dimensional article. It may be a machine, AC, fridge, TV, washing machine, anything which has got a three-dimensional shape. If it has some aesthetic value associated with it, then that can be protected under the Designs Act 2000. It is called a design. So the term of protection of copyright is 60 years. Patent is 20 years. So as you can see, the patent, if we talk about patent specifically, it should be novel, it should be non-obvious with respect to the prior art. Then the claim of invention must be disclosed in the specified format. And the term is 20 years. It is non-renewable, after which the invention falls in the public domain. So it means that everybody can use that particular technology on which you have got the patent after 20 years. So the trademark, when we talk about trademark, it is a sign, word, symbol, combination. It is basically a source identifier like Cadbury, Nokia, Samsung, all these words, the logo, the jingle. At times the jingle can also be trademark. Smell marks are also there, color marks are also there. This is just this type of intellectual property is to avoid the confusion amongst the consumers with regards to the source of the product. The term of this IP is 10 years. Like trademark registration, once you get it for 10 years, and it is extendable. It can be renewed for multiple times till your business stops. Actually, copyright, as I said earlier, it consists of musical work, literary work, artistic work, cinematographic work, sound recordings, lyrics, computer software. Now the copyright is vested in a work from the moment it is created. So once on the paper or computer you express your idea, the copyright starts the very moment. And it is advisable to get the copyright registered. It is not mandatory under the act. But in order to prove your case in the court of law, if somebody copies your work, then it is better that you should have a copyright registration. And the maximum term is the lifetime of the author plus 60 years after the death of the author. That is how much, that is the time for which you get the copyright protection. So design, as I said earlier, it includes the shape, configuration, ornamental and composition of lines or colors, which is applied to the article and which gives an appeal and just solely by the eye of the customer. The design should be new, just like patent. The shape and configuration of your product should be new and original and should not be disclosed by in the public anywhere in India or in any other country. And the period of protection in this IP is 10 years plus 5 years. So this is just a gist of various kinds of intellectual property which should not be mixed up by the innovator. And accordingly, whenever a new project has to be initiated, it has to be kept in mind that the resultant invention, whichever will be concluded, it will fall under what type of IP, and accordingly the inputs must be made, and accordingly it should be secured. Now it's a very classic example. As you can see, this is a pen. Now if I invent the nib of the pen in a certain fashion which is novel and different from earlier ones, which solves the problem associated with earlier pens, like it does not leak, it does not spill the ink to such a manner that it spoils the paper. If there are certain problems associated with the earlier pen, and if your new pen solves that problem, you can have a patent on that nib which you have invented. The aesthetic view of this pen, as you can see, it is very novel, very new. So this shape, pattern, configuration of this pen can be protected under the Designs Act. The artistic color combination on the pen, the way it is presented, the way it looks, can be protected under the Copyright Act. And when generally we see the pens like when you talk about Parker, so the word Parker which is inscribed on the pen is protected. The word Parker is protected under the Trademarks Act. So another very good example which covers all kind of intellectual property is a mobile phone. So when we talk about mobile phone, so the brand Samsung or Apple is a trademark. When you switch on the phone, you see the screen, the graphical user interface of the phone is protectable under Copyright Act. The system inside the mobile phone, we have all heard about Apple versus Samsung battle, which went on in US courts for decades. So that was all the war of patent war, basically. And so the all the systems which are inscribed in the mobile phone are patentable and they are patents. And the shape of the various shapes of the mobile phone, the placement of camera, uh, the size, the configuration, the shape is all covered under the designs. So once you understand what IP is and you start your project or invention in the direction wherein you can have some tangible or intangible asset in the form of an IP, what benefits it gives you? It gives you a better IP protection because when you spend time, money, and everything behind a research work, you always expect that you must get something in return, and that return is fortified by the fact that you have got your IP registered. So it gives you better protection. It stimulates innovation. From one innovation, if it is successful, you go on to the other projects. So it gives you a stimulant effect to go for more innovation and invention. It improves your R&D. Um, it provides better products in the industry. It gives you a bigger market, and ultimately we all work for economical growth. So IP can also assist in getting an economical growth. Now, what are the advantages? Just as you can see that it gives a genuine business will always be an integral part to the core services of your business. It prevents the competitors from infringing your products or your processes which you have invented. It gives you a corporate identity. You can earn money by licensing your intellectual properties to other companies, by franchising, by entering into contractual agreements. You can attract investors and financiers. You all must be aware about incubation centers, and after a product, a very good product is developed, it is generally put on in the market, wherein the startups and students, they pitch their ideas to the investors, and with the help of that IP you can get finances from the market, from the investors. uh, so that is how it is very much advantageous. Now we'll very go to the basic components of the IP, especially patents, because the topic itself includes innovation and idea. So it so as I understand, it is more about scientific inventions, wherein it includes patent as the main intellectual property, which can help you secure the invention or the innovation which you are proposing, and what you need to understand before you go ahead with the research project which you are proposing. So what is patentable and what is not patentable? So basically, when we talk about the Patent Act 1970, it defines that it should be an invention. An invention is patentable. It should be a new product or a process involving an inventive step and capable of industrial applicability. So as I said earlier, in the Patent Act, there was no process patent granted. There was only product patent granted. So for example, uh, you may get a patent on combiflam, right? You may not get the patent on the process. So ultimately that was introduced, and now product and process both are patentable under the Patent Act. What is new and novel? As Patent Act 1970 defines it is any invention or technology which has not been anticipated by publication in any document or used in any country anywhere in the elsewhere in the world before the date of patent application with complete specification. That is, the subject matter has not fallen in the public domain. So, as you must be aware, the Archimedes principle and the way he ran on the streets shouting Eureka, Eureka. So that is something which you must avoid when you have you have developed something groundbreaking, inventive, or innovative. It should not go into the public domain. It should not have been anticipated by any kind of publication. Generally, in India, it so happens that researchers and associates and even students, they make the mistake that very good patentable invention sometimes is published in journals, and that basically kills your novelty requirement when you apply for a patent. So that mistake even I have made during my pharmacy studies, which I would say that nobody should do. uh, when is novelty not anticipated? So basically, you may put your invention in some form or manner before you apply for a patent, and those publication will not be considered as something which kills the novelty. And under the act, it says that previous publication by any other person than the true and first inventor, previous communication to the government, maybe you may have submitted your project work to the government, that will not amount to anticipated by prior publication. Public display, etc., within 12 months before the filing of the application, that will not be considered as anticipated by prior publication. Public working for the purpose of reasonable trial. Now, you may put your invention for a trial wherein even the public is available to watch it. That will not be considered as anticipated. And use and publication after provisional specification. So once the date on which you file the patent, after that, if you publish somewhere, that will not be something which will kill the novelty factor of the patent, and that will not be cited by the patent office as an objection to your patent application. Now, anticipation in case prior publication by true and first inventor before filing of the patent, prior disclosure to any person, failing to file an application for grant of patent within 12 months of public display, prior public use or public working of the invention other than reasonable trial. So if you put a brochure or a pamphlet, or you put your invention on the website, or you put it on Facebook, the matter ends. Then you must forget that you will get a patent, because that was that the moment you uploaded it on the Facebook, it was not for the trial purpose. You revealed your invention to the entire world, so now you will not get a patent because you have published it. And prior use before filing of provisional specification. We also come across certain clients of ours who have already launched their product in the market, and then they get to know that it is an invention, it can be patentable. But unfortunately, we have to advise them that since you have already launched it in the market, we are sorry to say, but you will not get a patent since you have launched your product in the market already. Now, when we talk about novelty, how do we establish the novelty? So before you go ahead with the project work, what the innovator or inventor must check with regards to the project which they are proposing to do. First of all, you must crystallize the technical matter of invention. So if we talk about the pharmacy field or the pharmaceutical studies, you must first decide what is already available in the industry, what is already available in the market, what problems are already solved by the prior patents, what technology is already available, and despite of those prior arts, despite of those available patents, despite of those products or processes, still what problems are being faced by the industry or the patients or the customer or the purchaser. And then you distinguish those prior arts with your proposed invention, and that is how you establish the novelty. So when you file the patent application, you must always try that as far as novelty quotient is concerned, you must not get an objection from the patent office. That should be the first hurdle which has to be crossed. What is classified as prior art? So when I say prior art, what actually it means? Any information which is related to the field of invention which is in public domain. It includes what? It includes video recordings, it includes newspaper, magazine, articles, speeches, textbooks, journal, paper, patents, website disclosures, etc. Not only in India, but anywhere in the world. Um, Many of the pharma students, doing their project work in M.Pharm, uh, they propose certain ideas like, sir, this has not been done earlier. But within 5 minutes, we all can, search on the Google and say that the XYZ thing has already been tried in Turkey, or it has been tried in Egypt by some research scholar or professor. So it is not novel. So it is not something that you should only rely on Google or search engines, but you should also go through other platforms to check whether your proposed invention clashes with the prior art which is already available. So now what a young innovator or inventor must do? Uh, you must check scientific papers. You must read articles. You should watch technical or technological or pharmacy news which are available through various journals and magazines. The teachings which may be online, the products which are available, granted patents. It may so happen that the project which you are proposing has already been granted patent. The patent may have expired in many years back, so again you will not get again a patent over the same subject matter which was on which the patent has already expired. The patents which are already filed by somebody and are yet in publication, so on the very subject matter, unless and until it is groundbreaking and inventive, you will not get a patent. So what other things the inventor or innovator must note? You should not publish it first in any form which will destroy your chance to get a patent. So don't publish your invention or innovation. Do not delay, because patent is granted to the one who is first to file. So the moment you go ahead with your project, it has your project has reached to such a level where you know that in this direction, if you go ahead, you will get XYZ result, and that XYZ result is something which is novel, it is something which is inventive, it is something which is groundbreaking. The moment you realize that, you must straight away go for a patent registration. You should not wait for your end product to come, because that may take years. So it is always advisable that once you are very much sure that you can get XYZ result, you must go for a specific patent application with provisional specification. Provisional specification is something which is very broad. You specify the invention in very broad manner and you file it. This is to come out of the factor of delay that can kill your dreams to get the patent. So the inventors, while proposing the new project or idea, mainly focus on novelty. So that is not uh, something which can be put aside. But again, that is not something on which you should ride upon. They rely on what? Search strings on Google. We have come across some students who say that, when we searched our topic in XYZ manner on Google, we found 80 hits. Then we searched the very project matter in ABC manner and we found no hits in the Google search. So it is novel. So it is groundbreaking, but it is not so. You must understand that inventive step in industrial applicability is equally important. Now, during prior art search, merely novelty in the idea will not make the innovation patentable. What you must read, you must take the reference of eSpaceNet, which is the website or the platform available which provides access to European patents. It is the a website run by European Union. eSpaceNet gives you the idea about the patents already existing in Europe. WIPO patent scope. WIPO is basically World Intellectual Property Organization. It has its own platform called WIPO patent scope, which collectively includes the patent directory of almost all the countries who are member to the or signatory to that agreement. USPTO, of course, gives you access to US patent. INPAS